I'm Bob Merlin. I am a collaborative family attorney. I represent people who are going through a divorce, a paternity matter, or entering into a prenuptial agreement, and I do it in a private, respectful way. If you're thinking about getting a divorce, there are certain things you should know about the process itself. Ultimately, you will have to be in court for a judge to either decide what is going to happen or approve an agreement that you and your spouse have entered into. So let's back up. How do you get to that place? You need to understand that there are certain laws that apply. Some you can vary from, some you can't. Like laws about children are very important and judges are supposed to pay attention to them. If you have children, you need to decide how you're going to parent them. How are decisions going to be made? What time schedule are the two of you going to follow? When will the children be with each of you? There's something called a parenting plan in Florida that parents are expected to prepare, and it has the details of everything that you should be involved in as a parent in making decisions for your children. The parenting plan is available online, so you can find one. If you're going to file for divorce, somebody has to file a petition in court and pay a filing fee unless you qualify as being indigent. The filing fee is about $400 to $500 in Florida, and there are forms for the petition. The other spouse has to file an answer to that petition in court. An answer is something that is in writing that says, I agree or disagree with each paragraph in the petition that was filed by my spouse. Once that is done, then the court has the ability to have a final hearing and determine who's going to get what. The second person has the ability to file a counter petition as well, which says, okay, I know my spouse has filed for divorce, but I'm going to file for divorce as well. This is a little bit more detailed and not something that most people do, but if the first person decides to dismiss the divorce and the second person did not file a counter petition, then that's the end of the case. And the second person now has to go file a new petition. If you file a counter petition, then if the first person dismisses their case, then you're still in court and able to get a divorce. You can resolve everything without filing anything in court until you've resolved everything. So you can have an agreement and file a petition. One of you can file a petition, the other one files a simple answer, and then all you have to do is schedule a final hearing. If you can't agree to things, how to settle it, the judge will order you to go to mediation. Mediation is a private negotiation process using a third person, someone who's not related to anything going on in the case, to help the two of you negotiate a settlement. If you're able to negotiate a settlement, that agreement will be filed with the court and the judge will be asked to approve it as part of the final hearing that is scheduled. If you cannot agree in mediation, there will be a trial, and one of you will need to ask the court to schedule a trial. And you have to estimate how long the trial is going to take. Is it going to take an hour because there are very few issues? Is it going to take many days because the issues are very complicated and you have all sorts of experts who are going to testify? It just depends upon the circumstances of your matter. If you resolve everything and then file a petition, you can expect to get everything finished certainly in 2 months, and it can even be less than a month. If you don't resolve everything, your divorce can take anywhere from 6 months to multiple years. If this was beneficial to you, please feel free to reach out to me. Leave a comment. I'll be happy to review it and respond to you. And if you think there are other people who would benefit from this, please invite them to view this video. And I urge you to join this network because I'll be seeing you again in the future.